So hello everyone, welcome to today's lunchtime webinar on tackling common issues in cross-border transactions, and it will be presented today by our senior associate Ms Jasmin Yek. You can type any questions that you may have as we go along into the chat box, so if you just click onto the icon at the bottom of your screen, and we'll be recording it for future reference. So when Jasmin's finished the presentation, I'll put any questions that have come into her. All right, Jasmin.
All right, thank you so much, Catherine. Good afternoon, everyone. Welcome to our lunchtime webinar. The topic is tackling common issues in cross-border transactions. My name is Jasmin. I'm a senior legal associate at Concilium Law Corporation. And as you may know, Concilium Law Corporation is a Singapore law firm that specializes in corporate and commercial law, family law, civil and commercial disputes, employment law, wills and guardianship, mediation, and fintech. Please note that this is not legal advice, but it is, I'm just sharing based from my experience. And this is my brief biography. So in today's presentation, we'll be tackling a few issues. One will be the definition of cross-border transaction. Next one will be the common issues in cross-border transactions. Third will be contractual terms, and we'll focus on one aspect, which is the dispute resolution clause. Next, we'll also tackle the enforceability of the contract in another jurisdiction, and we'll have a brief summary of all the points that have been shared in today's presentation. So here is the billion-dollar question: what is a cross-border transaction? Simply, a cross-border transaction is a transaction between entities in two or more different countries. It could be between people or companies, or in today's world, globalization is a key part of today's world. So this is of increasing importance. You might find that in the course of your work, you are dealing with people from other countries, or you want to work in other countries with people from other jurisdictions. So if you have done any cross-border transaction, you would know that these are the usual factors that arise. When you do a cross-border transaction, you'll be working with people of different nationality, different race, speaking a different language, operating in a different time zone and location, having a different culture from you, having a different legal system from you, most probably, and operating under different laws such as tax implications, data protection, and the list goes on. Even when you want to make payment to them, you have to locate their bank account in probably another part of the world, which is very foreign to you. So what does this actually boil down to? When you deal with someone who does not really speak your language, it's an issue. If you deal with someone whose native language is not English, you might find that you might not understand his accent, or even the way he pronounces his words will be foreign to you. It's even harder if he doesn't even really speak English. Having a different time zone also poses difficulties. For instance, as you know, there are countries that, like Canada and parts of the United States, that are 12 hours behind us. So if you need to deliver something urgently within that day, if you are operating within their business hours, you'll find that you have to stay up late at night in order to meet their business hours. So one party will have to stay up late to get the work done. Having different cultures is also a problem. When doing business from people of other countries, you might not actually know how to deal with them or how to get along with them. One experience I have is working with people from China. So when you have clients from China, they like to have banquets where they will discuss the work, and they would basically get to know each other better. So one aspect of these banquets tends to be drinking baijiu, or in other words, direct translation would be white wine, which is a local wine made in China. And it is actually polite to show your sincerity for the transaction by toasting the main people involved in the transaction. And I was told that if you are unable to toast in alcohol, like for myself, because I'm actually allergic to alcohol, you have to toast in tea. And since you're toasting in a non-alcoholic beverage, you have to toast several times more than the usual amount in order to show sincerity. So that is an aspect of Chinese culture that you might find if you're dealing with people from the mainland. Having different laws also makes it difficult to navigate at times. In Singapore, if you have a contract that is governed by foreign law, if you have a litigation in court, you will have to prove it as a matter of fact. You will need expert evidence to explain it, and you might be even directed by the Singapore court to refer the matter of law to a foreign court. So in this case, if you do not even know what the law is, how would you use it to govern your contract? This is what we'll look at in the next slide. So when it comes to a cross-border transaction, the most important part of it actually boils down to the contract. It's good to have something in writing to tie down the parties to what they have agreed on. This will be used as evidence in the event of a dispute. And in our experience, most of the time when people sign or are involved in a business deal, they do not actually think too much about dispute resolution until it is too late. They usually think that nothing will happen, that everything will go well, and the contract will go on smoothly, and parties will just receive their benefits under the contract and they'll be able to walk away. But it is actually prudent to think about how you resolve a dispute if it arises. So key points when it comes to contractual terms will be the language of the agreement and the governing law. When it comes to the language of the agreement, it is good to think about where you're enforcing the contract and put it in that language. If you are dealing with, for instance, as I mentioned, I had some experience dealing with clients from China. If you intend for the contract to be maybe governed by either Chinese law or by Singapore law, and you want it to be enforced in China one day, it is actually good to have a direct translation of the contractual terms in English. You put a translation in Chinese alongside each term so that it is easy for the court to see what the parties agreed. And it's also difficult for the party to say that he did not understand the contract. Another aspect would be the governing law. So usual ways of choosing a governing law would be to choose the law of your country, the law of the counterparty's country, or neutral governing law. In our experience, it's actually better to use the governing law of your own country if you're familiar with it, because if you're not familiar with what the neutral governing law is or the law of the counterparty's country is, you wouldn't know how your contract will be construed according to a law of that country. It is best at this point to seek legal advice, even if you do not have a lawyer or in-house counsel to help you. It will be good to have someone legally trained to take a look at your contract for you. And this brings us on to the next part about contractual terms, that there are actually things that in Singapore law, like for instance, contra preferentum, is actually a doctrine where if there is doubt about the meaning of a contract, the words will be construed against the person who put them forward. Therefore, if you are the drafter of a contract governed by Singapore law, you have to be very careful in cases of ambiguity, because if there's any ambiguity, it will be construed against you. So moving on, we will talk about dispute resolution clauses. And the dispute resolution clause would simply state how you would like the dispute to be resolved in event of any dispute arising. One aspect of a dispute resolution clause is the jurisdiction clause. You might choose to either have your jurisdiction clause drafted so that the courts of one country have exclusive or non-exclusive jurisdiction over a dispute arising from that contract. To resolve from an exclusive jurisdiction clause or even a non-exclusive jurisdiction clause taken at its highest, one has to show exceptional circumstances amounting to strong cause that he will be permitted to bring his case outside of that contractual forum. If you use a non-exclusive jurisdiction clause, you essentially leave it open. However, this non-exclusive and exclusive jurisdiction clauses have been treated by the courts of Singapore on a case-by-case basis based on their exact wording. So in recent cases in the Singapore courts, we have noted that there is a new type of jurisdiction clause where multiple jurisdictions are stated, such as that of the country of incorporation, where the parties have their assets and where the party chooses to sue. So all these will be treated by the court on a case-by-case basis. Another type of clause that we have seen is the asymmetrical jurisdiction clause, which I understand are popular in documents drafted by banks. What the asymmetrical jurisdiction clause is that parties basically agree to the exclusive jurisdiction of one country, but one party, usually the one with the stronger bargaining power, elects to bring its action in a jurisdiction of its choice. So in Singapore, a similar clause was taken to mean that parties had irrevocably submitted the jurisdiction that they agreed upon. So what happens if your jurisdiction clause states that parties should have the courts of a country outside of Singapore decide on the case? So in this case, a stay of the proceedings will be considered applying the factors in Spiliada Maritime Corp versus Consulates Limited. based on the doctrine of forum non-convenience. Okay, basically what forum non-convenience means is that the Singapore courts will decide on which jurisdiction is the most appropriate forum to hear the matter. If Singapore is not the natural or more appropriate forum, a stay of the proceedings will be granted. The natural forum is the one with which the action has the most real and substantial connection. The court will take into consideration factors affecting convenience or expense, such as the availability of witnesses, and other factors such as the governing law, which we touched on briefly, and where the parties respectively reside or carry on business. If the court considers that there is no other available forum which is clearly more appropriate for the trial of the action, it will refuse a stay. However, the second stage of the test means that if the court concludes that there is some other available forum which prima facie is clearly more appropriate for the trial of the action, it will ordinarily grant a stay unless there are circumstances by reason of which justice requires that a stay should nonetheless be refused. Touching briefly on service of court process out of jurisdiction, if you want to sue from Singapore, you want to sue a foreign defendant or which is either a person or a company outside of Singapore, you will need the leave of the Singapore court to serve your process out of jurisdiction. And one of the factors would be to show that Singapore is a more appropriate forum to hear the matter. So this concludes our portion on litigation dispute resolution clauses, and we'll move on to the next type of dispute resolution clause, which is on arbitration. Arbitration is a confidential, it's a adversarial form of dispute resolution, which is by parties' consent. It may be expensive, but the difference between arbitration and litigation is that in litigation, the court appoints the judge hearing your matter, so you don't have any power to choose who will hear your matter, unless of course you challenge the judge's ability to hear a matter. But in arbitration, you can choose your arbitrator if the other side agrees. This means that if you know that your contract contains a certain way of that it should be read, you can actually choose the arbitrator that you know be favorable towards that interpretation. Arbitration agreements are actually a separate clause from the contract itself. So the seat of the arbitration is very important. That means where is the arbitration going to be held? The procedural law governing the arbitration actually is derived from the seat of the arbitration. And this law is actually can be different from that of the governing law of the contract. So it is actually good to have someone look at your arbitration clause. Many people actually use the model clauses available from the body administering the arbitration. But if you want to modify it, it will be good to get legal advice on it. And one thing good about arbitration is that if you have an arbitration award in one jurisdiction, you can enforce it in jurisdictions of other signatory states to the New York Convention. As of March 2020, 163 countries are signatories to the New York Convention, which means that it's a good choice to put an arbitration clause if the counterparty actually resides in a jurisdiction which is a signatory to the New York Convention. However, do take note that arbitration might actually cost quite a bit in today's times. The next type of dispute resolution clause is the mediation clause. Mediation is a good way of resolving disputes if you want to preserve the relationship between the parties. And why do I say that? It is because it is informal and it focuses on finding a solution for both parties that may not be based on the way the matter will be heard by a judge or by an arbitrator. It's not based on legal outcomes. It is also confidential and it's relatively fast. Some mediations take half a day to a day, which means that you can save the cost that you otherwise spend on litigation or arbitration, and you can get your dispute resolved quickly. And another good point about mediation is that under the Singapore Mediation Convention, international settlement agreements resulting from mediation concluded to resolve a commercial dispute can be enforced in about 52 countries as of now, and the convention enters into force on 12 September 2020. So a mediation clause will be a good way of resolving disputes. And another form of resolving disputes will be to put a mediation clause that also allows the matter to be referred to arbitration if mediation fails. So that is another way. And I think there's also arbitration first and then mediation and then arbitration. So these are all different ways of dispute resolution clauses that you can use. Finally, we go on to the topic on enforceability of the contract in another jurisdiction. So what happens now is that if you have followed the steps that we've gone through, you actually have a written contract in a suitable language, having a suitable governing law, and you have all the evidence that supports this contract, and you have everything that you need. But now you want to enforce the contract in a jurisdiction, and then you realize that the courts of that country might not be upholding the rule of law, or there might be corruption even among the lawyers and judiciary there, and you will not obtain justice there. So in this case, it is good to take a look at the jurisdiction that might be hearing your matter. You can actually see on Transparency International's corruption website that you can find that there's a corruption perception index, which states how the corruption level of that country is viewed by Transparency International. And of course, you may also look at the language, the culture, and different time zone when you enforce the contract. If the court applies a different language, do you have to spend additional money in translating all your contracts, translating all your documentation to that language? And how will you be treated in that court as a foreigner? And also the different time zone would be that when your lawyer in the other jurisdiction is going to court, what time is it for you? And are you able to keep yourself updated or give him instructions if he needs your urgent instructions for attending court? Another factor to take note of would be the travel to a jurisdiction, whether you need to travel there to give instructions, pass the lawyers your documents, whether you need to travel there to attend court. It is an additional expense. And also the availability of witnesses, how you can compel witnesses to attend trial for you, to give evidence for you. And if the witnesses are in another jurisdiction, how will you pay for their travel, for their food, for their refreshments? So that is another factor. So in summary, we have to go through the things that we've gone through today. Basically, it is to get legal advice where possible in your transaction, sign an agreement in writing, consider the governing law and language of the agreement, consider where and how you wish to have the matter resolved in the event of a dispute, do a due diligence on the counterparty, like where does it have its assets, where would you like to sue, and do a due diligence on the courts of the country where you wish to resolve your dispute or enforce a judgment, settlement, agreement, or award. And with this, we come to the end of the presentation. And at Concilium Law Corporation, we are more than happy to address your legal needs and advise you with regards to any part of your transaction, be it from the memorandum of understanding to the due diligence, negotiations, drafting of agreements, and closing items. Thank you. I'll hand it over to Catherine.
Thank you, Jasmine. So I just have a few questions here for you. So number one, what are some of the common jurisdictions chosen as seats of arbitration?
Okay, common seats of arbitration would be Singapore, London, Paris, Hong Kong, Dubai, Geneva, New York, and Stockholm. And Singapore is actually a hub for international arbitration and dispute resolution. So,
and so in Singapore, if you were looking at having a mediation on your matter, how would you go about that, and where would you get that done?
You could get it done in either the Singapore Mediation Centre or the Singapore International Mediation Centre, or you could ask a mediator to do a private ad hoc mediation. Franca, our managing director, is a mediator under United Nations, and she's able to assist. And also you might also encounter mediators when you have court matters where the court will actually appoint a mediator at some point when the parties go for alternative dispute resolution.
Okay, thank you. And just time for one more question. So who is best able to do due diligence on a company located overseas?
If you wish to do due diligence on a company located overseas, we are more than happy to recommend lawyers to assist. And also, it may be also conducted in conjunction with other experts such as auditors, accountants, experts in environmental matters, or human resources.
Okay, thank you very much, Jasmine, for the presentation today. And as Jasmine mentioned, if you do have any further questions, then please don't hesitate to email in to Jasmine or to any of the other team at Concilium Law Corporation, and you'll be able to review the slides and this video recording on our Concilium Law website and our Facebook page. Thank you very much for joining us today.